Welcome to Byju's exam prep. Yesterday, we initiated a discussion on citizenship. In citizenship, we first looked at what do we mean by this concept, citizenship. And there we discussed the best definition of citizenship can be the definition given by Hannah Arendt, which means citizenship is the right to have the rights. Then we discussed that Article 11 gives power to the Parliament that through a law you can regulate all matters related to citizenship. And that is how in 1955 a law was passed by the Parliament called the Citizenship Act 1955, which has been amended multiple times. It is through this law that we come to know that there are 5 ways of acquiring Indian citizenship: by birth, by descent, by registration, naturalization, and by incorporation of a foreign territory. And there are 3 ways by which one can lose the citizenship. 1, renunciation, termination, and deprivation. Then we discuss the concepts such as who was a person of Indian origin, who is an overseas citizen of India card holder, and also who is a non-resident Indian. Then we discussed the 2019 amendment of the Citizenship Act. And what was that amendment? Citizenship Amendment Act, which said if there are individuals coming from Pakistan, Afghanistan, Bangladesh, and they have come to India on or before 31st of December 2014, and they belong to 6 religious minorities: Hindus, Christians, Buddhists, Jains, Sikhs, and Parsis, religious minorities of these 3 countries, they shall not be deemed as illegal migrants. That means even if today a question is asked, can an illegal migrant become the citizen of India? Or can children of illegal migrants become the citizen of India? The answer is no. Sir, what about those so-called illegal migrants who have come to India from Pakistan, Afghanistan, Bangladesh, belonging to the 6 religious minorities on or before December 31, 2014? They are not deemed as illegal migrants. So although they are, but we say they are not illegal migrants. When they are not illegal migrants, that means they're eligible for citizenship through naturalization. We discussed the arguments in favor of Citizenship Amendment Act, how this law is good, and we also discussed some of the critical aspects of this law when we discussed the arguments against the Citizenship Amendment Act. Then we also looked at what is this concept of NRC, National Register of Citizens. This list contains the details of only the Indians. This list was first published in 1951. After that, it was not updated. Something happened in Assam. What happened? There was an agitation against the illegal migration into Assam, which the local Assamese people said violates, changes our demography, violates our culture, and we want to preserve our culture, our language, our script. Ultimately, this agitation lasted for about 6 years between 1979 and 1985, and ultimately this accord was signed, known as the Assam Accord. This accord was signed in 1985, and according to this accord, whoever has entered Assam before 1st of January 1966, they are the citizens of India, they can reside in Assam. But whoever has entered Assam between 1st January 1966 till 25th of March 1971, they will have no political rights for 10 years. Which means for 10 years, these people who have entered Assam during this period, they cannot contest elections, they cannot vote. But whoever has entered Assam after 25th March 1971, those are to be identified and those are to be deported. That means they cannot register as the citizens of India, they cannot reside in Assam. Where is all this mentioned? Section 6 capital A of the Citizenship Act. When was this section added into the citizenship law? 1985. In response to what? Because of the Assam Accord. Because the Assam agitation, which was launched predominantly by the students, led by an organization known as ASU, All Assam Students Union, and agitation continued for 6 years. Their principal demand was all these illegal migrants, they are to be identified, arrested, and deported. It doesn't matter whether these illegal migrants are from other parts of the country or these illegal migrants are from Bangladesh. Whether these illegal migrants are Hindus, Muslims, or from any other religious community. Just that these illegal migrants are to be identified, arrested, and deported. In response to this Assam Accord, because of this Assam Accord, even the Citizenship Act was amended to provide for Section 6 capital A of the Citizenship Act, which talks about these timelines. If you have entered Assam before 1st January 1966, if you have entered Assam between 1st Jan 1966 till 25th of March 1971, if you have entered Assam after 25th March 1971. In fact, in this Assam Accord, there was a clause 6. Why we have to discuss this? So that you do not confuse clause 6 of the Assam Accord with the section 6 capital A of the Citizenship Act. What was clause 6? That legal, administrative, constitutional safeguards should be implemented for the indigenous Assamese. If you look at Assam today, the society is widely viewed into two groups. One, who are the original inhabitants of Assam, and those who have come to Assam from other places. For example, the Bengalis. But clause 6 of the Assam Accord said, although whoever has entered Assam before 1st Jan 1966, we will accept them as the residents of Assam, we will accept them as the citizens of India, but they may not be the original inhabitants of Assam. But who are the original inhabitants of Assam? Those who have remained in Assam from the Ahom period, those who have remained in Assam since eternity, all those should be identified. So that through law, through some administrative means, through some constitutional protections, we can safeguard the interests of the Assamese people, the indigenous Assamese people, the original Assamese people. That is why if you look at the statements of the Assam Chief Minister, Mr. Himanta Biswa Sarma, he says that even Muslims in Assam are into two groups. All the Muslims are not from the Bangladeshi side. All the Muslims are not from the Bengali side. There are some Muslims who are the original inhabitants of Assam. And according to Assam Chief Minister, there are some communities in Muslims, for example, Gorias, Morias. Those are the original inhabitants of Assam, and significant safeguards should be implemented so that these indigenous communities are protected. That was clause 6 of the Assam Accord. But be that as it may, now when Citizenship Amendment Act was passed in the year 2019, it was challenged before the Supreme Court. challenged on the grounds that it violates the basic structure of the constitution, which is secularism, challenged on the grounds that it is discriminatory against a religion, challenged on the grounds that it is arbitrary, because without any logic, you have chosen a cutoff date, 31st December 2014. Without any logic, you have chosen only the three countries in our neighborhood, Pakistan, Afghanistan, Bangladesh. Without any logic, you are mentioning only the 6 religious communities. What about the Muslims who have been attacked, the secular Muslims who have been attacked in Bangladesh, in Pakistan, in Afghanistan? What about the atheists? What about the Jews? All this is arbitrary. That's the challenge before the court. But then the petitioner said, and Supreme Court agreed, that before we will hear Citizenship Amendment Act, the challenge to CAA, we will first hear the challenge to Section 6 capital A of the Citizenship Act. Why? Because Assam is the only state in India which has a different cutoff date for citizenship. When we discussed Part 2 of the Constitution, citizenship, there I told you about Articles 5 to 10. That Articles 5 to 10 were relevant at the time the Constitution was enacted. Because these articles talk about who is the citizen of India, who has remained within the territory of India for 5 years. What will happen to those who have migrated from India to Pakistan? They will lose their citizenship. What will happen to those who voluntarily give up their citizenship? They will lose their citizenship as well. What will happen to those who take the citizenship of another country? They will lose the citizenship of India. What will happen to those who are in Pakistan but want to come back? Till what time can they come back to India? And for that, the cutoff date was, can anybody tell me what was the cutoff date? For the rest of the country, if you want to come back to India from what is now Pakistan, you have to come back to India on or before July 19, 1948. That is the cutoff date for citizenship. But what did the 1985 Assam Accord do? It led to the amendment of the Citizenship Act of 1955, according to which Assam has a different cutoff date for citizenship. If you have entered Assam before 1st Jan 1966, you are a citizen of India. So can there be two different cutoff dates? One for the rest of the country, one for specifically Assam. That is the challenge being heard by the Supreme Court right now. And once this challenge will be heard, then the Supreme Court will hear whether Citizenship Amendment Act is constitutional or not. Assam Accord also talked about NRC specifically for Assam. What is NRC? National Register of Citizens, which contains the details of only the Indians. So if we have to identify who are the Indians residing in Assam, for that we need to implement the NRC, so that we can know who are these people who entered Assam before 1966, after 1966, between 1966 to 1971, after 1971. For that, NRC was to be carried out only in Assam. But could not happen. Matter went to the court. Sarbananda Sonowal approached the Supreme Court. Supreme Court directed the government should implement NRC in Assam. And NRC was implemented only in Assam. And once it was implemented, 1.9 million individuals could not prove their citizenship. When 1.9 million people could not prove their citizenship, Mr. Amit Shah, other members of the government, they said, we will not only implement NRC in Assam, we will now implement NRC in the entire country, and we will identify who are these illegal migrants. Clear? And that is how CAA came to be under a lot of criticism, because it impacts our foreign policy as well. How? Mr. Amit Shah, when he is the Union Home Minister, when he introduced this bill, citizenship amendment bill in the parliament, he was asked, why have you excluded Muslims from CAA? Why don't you also include Muslims and give them citizenship as well? Mr. Amit Shah said, prove to me that Muslims are discriminated in Pakistan, Afghanistan, Bangladesh, and I would be happy to grant them citizenship. How can Muslims be persecuted because of their religion in these three countries? Because these are Islamic countries. It's the religious minorities in these countries who are being targeted, persecuted for their religious ideology. Mr. Amit Shah said, if you can prove to me that Muslims are being targeted because of their religion, persecuted because of their religion in these countries, I'll be happy in granting them citizenship. But this runs counter to our arguments before the United Nations, before G20, before other international forums, that Pakistan is a rogue state. We always claim that Pakistan is not even sparing its own people. Pakistan is killing Muslims in Balochistan. Pakistan is killing the Shias. Pakistan is killing the Ahmadis. These are different sects of Islam, Shias, Ahmadis, and others. And in Pakistan, these sects have been continuously targeted. So we go to the international forums at the United Nations, in our dealings with United States and other countries, we say Pakistan is a rogue state. It is not only attacking us through terrorism, it is not only infiltrating our borders and sending terrorists to Jammu and Kashmir, it is also attacking its own citizens in Balochistan, the Ahmadis, the Shias. So on the international front, we say Pakistan is attacking Muslims. But inside the Indian Parliament, the Home Minister is saying, prove to me that Muslims are being persecuted in these countries and I will be happy in granting them citizenship. So these are contradictory statements. Tomorrow it might impact our foreign policy when our foreign minister would visit important countries or would speak at United Nations telling the world community that Pakistan is attacking Muslims as well. They might well and argue that what about the statement of your Home Minister who said on the floor of the parliament that Muslims are not targeted and persecuted in these countries? That's the challenge number one. Challenge number two, Taliban has now taken over Afghanistan. And in Afghanistan, there are different tribes. There are Hazaras, there are Pashtuns, there are Uzbeks, there are others. Taliban is basically an organization of the Pashtuns, which is one dominant tribe in Afghanistan. So let's say, for example, there are three important tribes in Afghanistan. We have to at least win over one tribe or two tribes so that they can safeguard our interest in Afghanistan, because we have a lot of interest in Afghanistan. We have a lot of investment in Afghanistan. One such tribe who can be of some help to us are the Hazaras of Afghanistan. But we are now saying that Hazaras of Afghanistan also, because they are Muslims, they are targeting non-Muslims in Afghanistan. So that will also dent some of the relationship that we have with the Hazaras. If we look at our neighborhood, China is like an octopus with all its different aspects, countering, controlling various different countries of the world in our neighborhood. It is an important player in Nepal. It's an important player in Bhutan. It's an important player in Myanmar. It's an important player in Sri Lanka because of various investments in Sri Lanka. It's an important player always in Pakistan because Pakistan and China, they are all weather friends. One bright spot in our diplomacy over the past many years has been our success in dealing with Bangladesh. Some of the terrorists who had taken refuge in Bangladesh were handed over to us by the current Prime Minister, Sheikh Hasina. But after this law was passed, it was argued that what will happen to these illegal Bangladeshis who have entered Assam or other parts of the country? The government said, we will identify them and deport them. Bangladesh is saying, how can we accept them? We no longer consider them as citizens of Bangladesh. In fact, the Bangladeshi foreign minister had to come pay a visit to India after this law was passed. He cancelled the meeting, he cancelled the invitation, which means through Citizenship Amendment Act, it has had a significant foreign policy challenges as well. But Dr. Subramaniam Jaishankar, a very competent external affairs minister, he has proved to be an able diplomat as well. And he's been able to limit the damage which might have been caused through the enactment of this law. Clear? 2019 Citizenship Amendment Act also amended and added one more reason, one more ground on the basis of which your OCI card could be cancelled. I told you previously that there were 5 grounds originally on the basis of which your OCI card could be cancelled, but all those grounds were clear cut. Clear cut in the sense there was no room of ambiguity. If you have acquired, registered for an OCI card through fraud, if you are disloyal to the constitution, if you are a threat to the sovereignty, integrity, security of the state, if you have been arrested and sentenced to 2 years in jail within 5 years of getting the OCI card, so all these were genuine reasons on the basis of which your OCI card could be cancelled. Now a wide ground has been added. Your OCI card could be cancelled if you violate any law that is in force in this country, which means very vague. Vague in the sense you are driving a motorcycle, you're driving a car without wearing a helmet, without a driving license, which means you're violating the Motor Vehicles Act. On this ground, your OCI card could be cancelled. Although no violation should be condoned, but there are some laws which you violate, there should be punishment for you in the form of a fine. But this punishment cannot be so massive as to cancel your OCI card. That is the problem with the 6th ground which has been added, which gives a wide power to the government that it can cancel OCI card of any individual. If you violate any law, you should specify which are these laws that you should not violate. Don't mention any law because it gives a wide sweeping power to the government. All this is part of the Citizenship Amendment Act. Now we will combine CAA plus NRC, and we will also add NPR to the list, and then look at the relationship between these 3 different aspects. Listen to me carefully. What is NRC? National Register of Citizens. What is NRC? First updated in 1951. What is NRC? Contains the details of all Indians, which means contains the details of only the citizens of India. Correct? What is CAA? Citizenship Amendment Act, which means if you are from Pakistan, Afghanistan, and Bangladesh, and if you have entered India on or before December 31, 2014, but you belong to Hindus, Christians, Sikhs, Buddhists, Jains, and Parsis. Then what happens? You become eligible for citizenship. Yesterday, somebody had posted a question. Anandu sir, first updated or last updated? First updated in 1951, and that was the last time also this was updated. Clear? Yesterday, somebody asked a question, said, why were there protests at Shaheen Bagh? Why were the Muslims protesting against the CAA? Mr. Amit Shah, outside of the parliament, he gave various speeches, he interacted with the media, and what he said, he talked about some chronology. He said, first there will be CAA, then there will be an NRC. And through this double combine, we will eradicate illegal migrants from this country. That raised a lot of eyebrows, and some people thought, particularly the Muslim community thought, that this CAA and NRC has been primarily used or will be primarily used to disenfranchise Muslims, to deprive Muslims of their citizenship. How? Let's say, for example, NRC, when it was carried out in Assam, 1.9 million people could not prove their citizenship. Why? Because of lack of documents. You and me, we may have a lot of documents. We may have a passport, we may have an Aadhaar card, although Aadhaar is not a proof of citizenship. Aadhaar is only a proof of identity. Even the foreigners are eligible for Aadhaar. All those foreigners who have stayed in India for 6 months, they are eligible for Aadhaar. You may have a passport. You may have a matriculation certificate, a 10th standard pass certificate. But what about those who are illiterate? They may not have these certificates at all. So how can they prove their citizenship? Also, not just this, there have been riots in different parts of this country as well. And in these riots, property has been destroyed and burnt as well, which means some of the important documents may also be burnt. So how can you prove your citizenship? By submitting these documents which have been destroyed in riots. Forget about riots, which may have been destroyed in earthquakes, in tsunamis, in landslides. So there are millions and millions of people who may be Indians, who may be genuinely Indians, but because of lack of documents, they cannot prove their citizenship. That's exactly what happened in Assam. 1.9 billion people could not prove their citizenship. Now, if this NRC is carried out throughout the country, maybe not 1.9 million, maybe 19 million, maybe 190 million may not be able to prove their citizenship. Let's assume this number is 100 million. 100 million people are unable to prove citizenship. When 100 million people are unable to prove citizenship, then what will happen? Some of these people may be Hindus, Christians, Buddhists, Jains, Parsis, and Sikhs, and some of these people may be Muslims as well. But what will happen to these 100 million people? They will be fed to a filter. And that filter is Citizenship Amendment Act 2019. That means all these 100 million people will be fed to this filter. And who are filtered out? If you're Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, you will be granted citizenship. All you have to say is that we are from Pakistan, Afghanistan, Bangladesh. All you have to say that we have entered this country on or before December 31st, 2014. That means only the Hindus, Christians, Buddhists, Sikhs, Jains, and Parsis, they will become eligible for citizenship through CAA. Then they will become part of the NRC. Who is the only community which is left out? The Muslims. So that is why at Shaheen Bagh and at different places, Muslims were protesting or others were protesting for Muslims because they thought that it is this combined CAA plus NRC which is used with a specific purpose to disenfranchise Muslims, to deprive Muslims of their citizenship. Because all the illegal migrants, they will be granted citizenship through CAA except Muslims. And through this NRC, which is carried out throughout the country, if it is carried out throughout the country, there will be millions of people who may be Indians, but they will not be able to prove their citizenship. But everybody else would be accommodated except Muslims because CAA is not applicable for Muslims. There was a lot of hue and cry, lots of protest, and ultimately Mr. Modi, the Prime Minister, said something. He said, when I came to power in 2014, till today in 2019, we have never discussed NRC. Basically countering Mr. Amit Shah, who said that there is a chronology. First, there will be CAA, then NRC will be implemented throughout the country. And then illegal migrants would be eradicated from this country. And then, because COVID-19 lockdown hit the country, the protests disappeared, and ultimately the protest against CAA also disappeared. But while all this was happening, the government came up with something else known as NPR. National Population Register. What is National Population Register? First done in 2010, then updated in 2015, was to be updated in 2020, postponed because of pandemic. And what is this National Population Register? NPR contains the details of all the usual residents of India. Who are the usual residents of India? Who are staying in India for 6 months or more, or those who want to stay for 6 months or more. What is NPR? It was first implemented in 2010. Then it was updated in 2015. Then it was to be updated again in 2020. But because of the COVID-19 pandemic, it could not be implemented. But what is this NPR? National Population Register. What is NPR? It contains the details of all the usual residents of India. Who are the usual residents of India? Who are residing in India for 6 months and who want to reside in India for 6 months. Which means those who want to reside in India for 6 or more months may be citizens, may be aliens as well. So all those who are residing in India for 6 months or those who want to reside in India for 6 months, who can these individuals be? They can be either citizens, they can be aliens as well. What is the purpose of NPR? The purpose of NPR, according to Mr. P. Chidambaram, because he was the Home Minister in 2010 when NPR was implemented for the first time, the purpose was to look at the migration of the people within India. I may be from Karnataka, but I'm staying in Maharashtra for 6 or more months. Which means in Maharashtra, there should be some scheme for me if I'm poor, if I'm from the vulnerable community, if I'm a migrant, if I'm working as a street vendor, there should be some specific scheme for me. So how schemes can be made basis on the migration of the people. Whether you are staying, you may be from Delhi, but you are staying in Karnataka. You may be from Karnataka, but you're residing in Tamil Nadu for 6 or more months. which means we have to look at those people and have schemes tailor-made for them. That's how NPR was to be carried out. Because what is census? Census tells us the overall population number. And the census figures data is secret. Secret in the sense, you may come to know what is the population of India, but you will not come to know the details about the Indians. Because as an Indian, I have to give a lot of details to these census officers. What is my age? What is my place of birth? What is my mother tongue? What is my SC status? What is my ST status? What is the employment status that I have? If I am a woman, what is the fertility age? So lots and lots of information is to be provided to census officers. And all this information is secret, cannot be revealed. But NPR data is not secret. Why? Because we need this data for various schemes. That is how NPR was enacted or carried out in 2010. But in 2020, when this NPR was to be carried out, there was a lot of protest. Telangana said, we will not implement NPR. West Bengal said, we will not implement NPR. Bihar said, we will not implement NPR. Opposition state said, we will not implement NPR. They said this NPR is nothing but NRC in disguise. And since there are people protesting against NRC, we will not implement NPR because this is not NPR, this is NRC. Why? Because now new details you had to provide. Because in 2010, 2015, when NPR was carried out, questions were asked. Questions in the sense, census is carried out in two phases. First, there is house listing. Then there is population enumeration. What does that mean? The census exercise in India dates back to 1881. Although even before that, census would be carried out, but that was only carried out for a city. For example, in Dhaka, the census exercise was carried out. But full-fledged census throughout the country was carried out in 1881 for the first time. And then it became a decadal exercise. What is this decadal exercise? That means census is carried out every 10 years. 1881, 1891, 1901, 1911, 1921. Important is 1931. When this census exercise was carried out, census is normally carried out in two phases. First is house listing. So all the officers, all the people who are involved in census, they first look at the houses. They list the houses. How many houses are there in this town, in this district, in this village, in this city, in this state, in the entire country. So first, houses are to be listed. And then we go to these houses and we ask questions. How many people are there? What are you doing? What is your age? What is your place of birth? What is the name of your father? What is the name of your mother? What is the mother tongue that you speak? If you are a woman, what is the fertility age? So many questions. What is your SC status? What is your ST status? And in 1931, even SC status, ST status, other castes were specified. That means in 1931, when the census was carried out, till 1931, the census which was carried out, all the details, even the caste level details were provided. How many people belong to SCs? How many people belong to STs? SCs, STs, although it's a constitutional term, it came into force after the constitution. But all those who are now SCs, what was their population in 1931? All those people who are STs, what was their population in 1931? All those who are now OBCs, who are now part of the OBC group, what was their population in 1931? And the remaining, what was their population in 1931? How many Hindus, how many Christians, how many Sikhs? All this population figure was provided in 1931. But when the next census was carried out in 1941, what happened? In 1941, something else was going on. The Second World War broke in 1939, which continued till 1945. And the British government said, carrying out such a massive exercise is expensive because we need to save money, because we need this money to fund war. We need to kill a lot of people in the Second World War because we are always involved in the world wars. For World War I, World War II, and who knows, World War III either. So we will not go down and identify other castes. We will only identify the backward castes and the backward tribes. And that is how caste level data is not present even today. That means 1931 was the last time that we had a look at the caste-wise breakup of all the different castes and tribes in India. Now there is a demand that we should have a caste census. What is the caste census? That means even today, the last census when it was carried out in 2011, we have the breakup of how many SCs are there, how many STs are there. But we don't have the breakup of how many OBCs are there. That is the detail that we do not have. And that is why there is a demand that we should have a caste census so that we can know what is the percentage of the population belonging to OBCs as well, other backward classes as well. The Bihar government initiated this, said we will identify who are the other backward classes. How many are the other backward classes in Bihar? Matter went to the court. Why? Because the court was told that census is under union list. When you look at the distribution of powers into union list, state list, and concurrent list, item 69 in the union list is census, population enumeration. That means who has the power to conduct census in India? That's not the power with the state, that's the power with the center. And that is how the Ministry of Home Affairs, under the registrar, the commissioner of census, they carry out this census exercise every 10 years. So if census can be carried out only by the center, through census commissioner, under the Census Act of 1948, under various census rules. So how can the Bihar government carry out this census exercise? Bihar said we are not carrying out census, we are carrying out caste survey. So it's not a census. We know census comes under union list. It's not a census. It's a caste survey. And nobody can stop us from surveying the number of castes and what is the individual number belonging to a particular caste. Why? Because we have to provide schemes for them. For every scheme, for every policy, you need data. If we want to provide schemes for the marginalized communities, if you want to provide scholarships for them, support for them, we need to identify how many people belong to that community. Because that is how we can allocate resources to that particular scheme, to that policy, to that program. The last data that we had of other backward classes was in 1931. So we need this data today. We're not carrying out census, we're carrying out caste survey. And Supreme Court said, okay, you can carry out this caste survey, and the results were also released recently by the Bihar Chief Minister. And now yesterday, there was a meeting of the Congress Working Committee where the Congress has now said we demand caste census throughout the country. Karnataka said we will carry out a caste survey. Rajasthan said we will also carry out a caste survey. And it's also a very emotional issue. Emotional issue in the sense, if you read yesterday's Indian Express, talks about Mandal versus Kamandal. And what is that Mandal versus Kamandal? We will discuss how OBCs got reservation in the 1990s. At that time, Mr. VP Singh was the Prime Minister. He was supported by the BJP. He was supported by the left parties as well. And VP Singh government implemented reservation for OBCs. BJP then was viewed as a political party which had support amongst the upper castes. But the beneficiaries of OBC reservation would have been the other backward classes, not the upper castes or the Brahmins or the Thakurs. Because of Mandal Commission, this OBC reservation became possible. A committee was set up in the 1978. This was under a politician known as BP Mandal, and BP Mandal Commission recommended reservation for OBCs, which was implemented when VP Singh was the Prime Minister in the 1990. And then BJP was in a fix. BJP said, should we support this government because it is providing reservation to OBCs who are not our vote bank? Our vote bank are the upper castes. Or should we go back to the mandir? Let's have a nationwide program, a movement, a Ram Jannabhoomi movement for the construction of a mega Ram temple at the then disputed site at Ayodhya, because there stood a Babri Masjid. And the BJP's demand was that this Babri Masjid stands on the ruins of an ancient Ram temple where Lord Ram was born. And this mosque should be destroyed so that a Bhavya Mandir, a massive temple, can be constructed. BJP withdrew support to VP Singh and started this Mandir politics. That's according to Indian Express, not me. These are not my words. I don't know anything about what happened. But the point is, when the BJP is viewed as a political party which has a lot of support amongst the upper castes, amongst the people who are living in the city, amongst the educated people, the opposition wants to play this caste census issue so that we can identify who are these, what is the proportion, what is the percentage of the other backward classes as well. So that all the politicians which emerge from this Mandal politics, they would get benefit. Lalu Prasad Yadav was the product of this Mandal politics. So was the Samajwadi Party, the Mulayam Singh Yadavs and others, even the Nitish Kumars. These were the products of this Mandal politics which played in 1990 onwards. And to basically reap the political dividends, that is now the demand of a caste census is. But be that as it may, that is politics of the day. We don't have to get into that. We are basically looking at what is NPR. So what is NRC? We know that. What is CAA? We know that. What is NPR? NPR contains the details of all the usual residents of India. All those who are staying in India for 6 months, all those who want to stay in India for 6 months. This NPR was carried out in 2010, updated in 2015, was to be updated in 2020, but it was postponed because of the pandemic. And this NPR is normally carried out when house listing is done. Because census is carried out in 2 phases, house listing and population enumeration. This NPR is carried out during house listing phase. But this time, when it was to be carried out in 2020, governments of the opposition ruled state said, enough is enough, we will not implement this. Because this is not NPR, this is NRC in disguise. How? Because in 2010, when NPR was carried out, questions were asked, although you don't have to submit any proof. When people will come to your home, seek details about NPR, you don't have to submit any proof, but you have to answer questions. Questions such as, what is your name? What is your age? What is your sex? So on and so forth. But this time some questions were asked which were not asked previously. What was that question? What is your date of birth? What is your place of birth? Place of birth of parents. Aadhaar. So on and so forth. What's your place of birth? What is your Aadhaar? What is the place of birth of your parents? These questions were never asked in the previous NPR. Opposition said, critics said, this is not NPR, this is NRC in disguise. Why? Because NPR contains details of whom? Citizens as well as aliens. All those who are the usual residents of India. And it is mandatory to register in NPR. It is mandatory for every resident to register under NPR so that we know whether you are staying in India for 6 months or more. But this NPR, when the government said we are not implementing NRC, opposition said you are implementing NRC through NPR. Because till 1987, we were following the concept of Yas Soli, law of the soil, which means if you are born on the soil of India, regardless of the nationality of your parents, you are the citizen of India. But if you are born between 1987 to 2003, before 1985, yes, solely. But if you are born between 1985 to 2003, one of the parent has to be an Indian. If you are born after 2003, one of the parents should not be an illegal migrant. So all these details will be collected in NPR. Details will be collected. What was your place of birth? What is your date of birth? So if you are born before 1985 in India, you are a citizen. If you are born after 1985, you have to tell what is the place of birth of your parents. If you are born after 2003, you will also have to say what is the place of birth of your parent. If your parent is an outsider, which means you are no longer a citizen. That means the details from NPR, when this entire data will be published, we will easily come to know who are the citizens, who are the foreigners. And out of those citizens, we will also come to know whether you are a legal migrant or an illegal migrant. Parents to an illegal migrant or illegal migrant. That means opposition said, remove these questions. Why do you need these questions? You only need details so that you can find schemes for them. Just get the idea, how many Maharashtrians are there in Karnataka? How many Kannadigas are there in Tamil Nadu? What is their age? What is their sex? These are the details that you need for your various schemes. Why do you need details such as what is your place of birth? What is the place of birth of your parents? What is your date of birth? All these details point to that you want to conduct NRC in this country. But thanks to the pandemic, or because of the pandemic, even this NPR could not be carried out. When even NPR could not be carried out, even the census is delayed. In United States, in Japan, there is a statutory requirement. What is the statutory requirement? Every 10 years in United States, every 5 years in Japan, census has to be done, has to be carried out. It's a statutory requirement. It's a legal requirement. Census has to be carried out every 10 years. In US, every 5 years in Japan. But in India, census is carried out by the Ministry of Home Affairs, by the registrar and the commissioner of the census department. All this is done. Census is carried out under the Census Act of 1948. Census is carried out under various census rules, but it is not mentioned anywhere that census has to be carried out every 10 years. That means in India, there is no statutory requirement that census is to be carried out every 10 years. Although it was carried out every 10 years, right from 1881, carried out every 10 years, one by one, but last it was done in 2011. It was to be done in 2021, but stopped because of pandemic. That's what the government says. It is stopped, it is postponed because of the pandemic. But we are towards the end of 2023 and we see no sight of census carried out. If elections can happen, why not census? Yesterday, if you read today's newspaper, election schedule to 5 states has been announced. Whether it is Mizoram, whether it is Rajasthan, whether it is Telangana, whether it is Madhya Pradesh, whether it is Chhattisgarh, election schedule has been announced. So if elections can happen, why not census? And why census is important? Data. We need to allocate budget to various schemes. But how do we know what is the number of beneficiaries for each scheme? Because the data that we have is that of 2011. Today it is 2023. We don't know by how much percentage the population has risen. Not just that, 73rd and 74th Amendment it talks about Panchayati Raj institutions and municipalities. In Panchayati Raj institutions, in municipalities, seats shall be reserved. For whom? SCs and STs. What is the percentage of reservation of seats for SCs and STs in Panchayat and municipalities? In proportion to their population. Maybe 20% of the seats in Panchayat are reserved for SCs and STs, but basis on the population of 2011. If today their population is 30%, that means we are providing them limited reservation. We have to provide them actual reservation of 30%. That can only happen when census exercise is carried out. Even women's reservation is now to be provided. Because now finally a bill has been passed. Constitution has been amended. We need to provide at least 33% reservation to women in Lok Sabha and in legislative assemblies. But for that, we need to identify who and how many women do we have. We need to carry out census. So census data is a must. It is required because today our policy makers, they decide various schemes based on an old data of 2011. We need the current data and we need a law. We need to amend the Census Act to make it mandatory for the government to carry out census every 10 years. That completes our discussion on citizenship. If you have any questions, let me know. Then we will start with fundamental rights. Sir, what is the difference in information contained in NPR and census? I told you NPR data can be shared. Census data cannot be shared. So if you want, census data cannot be shared with any other department. There is some level of secrecy which is associated with census. NPR, we just need to look at what is the internal migration that is taking place so that we can have different schemes for them. That is why NPR has a different utility, census has a different utility. So before 2011, it was 1931 when SC/ST data was populated. SC/ST data is collected at every census, whether it is 1931 or it is 2001 or 2011. But other data, other caste data, population related or to the other castes, apart from SCs and STs, that was last collected in 1931 has not been collected now. Does Aadhaar play a role in citizenship? No, Aadhaar is just the proof of identity. Aadhaar only proves that X is X, nothing more, nothing less. Sir, but Bihar government is saying jitni abadi utna hak. Isn't that against the idea why reservation actually came? Tribals are only 8% and they need reservation and they're getting 17.5% reservation. But according to their demand, they will get only 8%. Will that be just for tribals? Tribals get 7.5% reservation, not 17.5% reservation. Sir, why those questions were added in 2010 for NPR? Those questions were added in 2020 for NPR, not 2010. Maybe the government wanted some more information. Maybe it was NRC in disguise. Who knows? Sir, then what is my proof of citizenship? Passport is one proof of citizenship, although when NRC was carried out in Assam, passport was not viewed as citizenship proof. So basically, the birth certificate that is issued to you by the district authorities, by the municipal authorities when you are born, that can be the proof of citizenship. Aadhaar is only a proof of identity. Sir, for census, they have to go to every house. So how can OBC question addition make it expensive? It's not only asking questions. Then you have to populate that data as well into various sheets as well. Ink, the manpower required for that. Ultimately, the costs will shoot up because you are talking about a massive population. See, what is the proof of citizenship that we will only come to know if at all there is an NRC exercise in India through which the government will want to identify who are the citizens. At that time, they will tell us what is the proof of citizenship. If you have a voter ID card, if you have a passport, if you have a birth certificate, any other certificate. So does census include caste data? Census includes caste data vis-a-vis SCs and STs, not of other castes. Sir, if in NPR people don't need to submit any proof, then there may be a chance of false information. Yes, there will be a chance, every possibility of false information, but that is only at the stage of house listing. When they will come for population enumeration, then they will have to submit something. Or tomorrow, basis that information, if NRC is carried out, then you will be held accountable. You gave the false information. Why Home Ministry is taking actions regarding citizenship? Why not external affairs? Citizenship is our internal matter. That's why it's under Home Ministry. External Affairs Minister has to deal with external matters. There is no rule in India to hold census every 10 years. Yes, there is no such rule. What is delimitation? That we will discuss in elections. Delimitation basically means, let's say Rajasthan. Let's suppose there are 100 seats in Rajasthan. Clear? But in these 100 seats, there is one seat, one constituency where we have 1 lakh voters. There is another constituency where we have 10 lakh voters. So 10 lakh people are represented by one individual. 1 lakh people are also represented by one individual. This is not justice. That is how in delimitation, the entire population of the state is divided equally into constituencies. That is the simple idea of delimitation. Although it is much more complex than this, which we will discuss in elections. Subramanya, what is your question? Sir, without passport, how can illiterate people prove their citizenship? Does that mean only educated people have passports? Doesn't. But passport alone cannot be the proof of citizenship. Something else can also be proof of citizenship, which the government will provide, which the government will specify. Everybody has a voter ID card. That may also be a proof of citizenship. I don't know. That's for the government to decide. Is Aadhaar proof I am the citizen of India? No. For that, you just look at your Aadhaar. Turn the backside. Aadhaar is not a proof of citizenship. Aadhaar is only a proof of identity. Only Aadhaar proves that you are Vishal. The Vishal you are claiming to be. Nothing else. Okay. Done. Shall we start fundamental rights? Okay. Let's look at part 3 of the Constitution, which deals with fundamental rights. And here we will have to discuss Articles 12 to 35. But you don't have to remember these article numbers, just understand the concept. But there are some articles which you must remember. And I will identify which are these articles. For example, Article 14, Article 19(1)(a), Article 21, Article 25, Article 32. These are the important articles that you must remember. And you will automatically remember all these articles once you revise this topic multiple times. What are fundamental rights? Look at the goals that are mentioned in the Constitution. Goals mentioned in the preamble, which should be implemented through this Constitution. Preamble talks about justice, social justice, economic justice, political justice. Preamble talks about liberty, equality, fraternity, dignity of an individual. All these are lofty goals that are mentioned in the preamble, which we have to achieve through this Constitution. And to implement all these lofty goals, there are 3 different parts that are mentioned in the Constitution. Part 3, Part 4, Part 4, capital A. Part 3 deals with fundamental rights. Part 4 deals with directive principles of state policy. Part 4, capital A, deals with fundamental duties. That means although these are 3 separate parts of the Constitution, 3 separate units of the Constitution. One is fundamental rights, directive principles of state policy, fundamental duties. Although they are separate, but their utility is that when we look at them together, what they try to do, they try to implement all those goals which are mentioned in the preamble to the Constitution. And when we look at these 3 parts separately, We can break them into three. Three in the sense, one is a negative obligation. Listen to me carefully. When you read all these fundamental rights, look at the wording of these fundamental rights. Article 14, for example, says the state shall not deny equality before law. Article 15, the state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this, the state shall not do that. That means, what are these fundamental rights? These are restrictions on the state, negative obligations on the state, that you don't have to interfere with the liberty of an individual. These are fundamental rights. And I will go back to the first class that we discussed. Doctrine of limited government. The powers available with the government, they are not unlimited. There is a limitation on the powers available with the government. That's what we call doctrine of limited government. And what are these limitations? Fundamental rights. What are fundamental rights? Basically, limitations on the state, restrictions on the state, negative obligations on the state. That state, you don't have to deny equality. State, you don't have to discriminate. State, you don't have to deprive an individual of his right to life and liberty. State, you don't have to interfere with the dignity of an individual. State, you can't do this. State, you can't do that. Restrictions on the state, limitations on the state. That is what we call fundamental rights. But when we look at part 4 of the Constitution, we talk about positive obligations in the form of directive principles of state policy. In fundamental rights, what do we say? We say that state, please stay away. Don't interfere with the liberty of an individual. Don't discriminate. Don't deny equality. Don't deprive an individual of his right to life and personal liberty. Don't do this, don't do that. Stay away. Stay away from the liberty of an individual. Less interference with the liberty of an individual. But in directive principles, we are saying positive obligation. State, please interfere. Please come, interfere. Why interfere? So that this gulf, this wide gulf that we have between rich and the poor, this gulf should be minimized. Please interfere so that we have equal pay for equal work. Please interfere so that we can set up Panchayati Raj institutions in India. Please interfere so that we can enhance the standard of living for every single individual in India. Please interfere so that we can protect our monuments, our pieces of national heritage. Please interfere so that we can implement uniform civil code in this country. Please interfere so that we can do this, we can do that. So that we can enhance the social status of an individual, so that we can enhance the economic status of an individual, so that we can provide livelihood opportunities to the people. Please interfere so that we can provide right to work to the people. Please interfere. Which means in fundamental rights, we basically tell the state, don't interfere with the liberty of an individual. But in directive principles of the state policy, we tell the state, please interfere so that in our social and economic sphere, we have development. And then the third thing is duties. As citizens, we have duties towards the state. As citizens, we will uphold the Constitution, respect the national flag and the national anthem. As citizens, we will renounce those practices which are derogatory for the dignity of the woman. As citizens, we will promote a sense of common brotherhood amongst the different members of the society. Why? Because one goal which is mentioned in the Constitution, which is mentioned in the preamble, one objective of the Constitution which is mentioned in the preamble is what? Fraternity. A sense of common brotherhood. And that we can achieve through fundamental duties. which means this chapter fundamental rights, where we have to discuss articles 12 to 35. When we look at this fundamental rights chapter, we need to at the same time have a close eye on DPSPs and fundamental duties. Why? Because all these three parts, part 3 fundamental rights, part 4 DPSP, part 4 capital A fundamental duties, although these are separate parts, although these are separate units, but what they try to do, they try to concretize, they try to give shape, they try to implement all the lofty goals that are mentioned in the preamble to the Constitution, where the preamble talks about justice, liberty, equality, fraternity, dignity of an individual, assuring the unity, integrity of India. And how do we implement them? Through fundamental rights. And fundamental rights, we say, there are restrictions on the state, negative obligations on the state. Don't interfere with the liberty of an individual. Don't discriminate. Don't deprive an individual of his right to life and personal liberty. That means in political sphere, the state should not interfere with an individual. There are restrictions on the state. But in society, in social and economic aspects, which deal with directive principles of the state policy, we are asking the state, please interfere so that you can enhance, through your steps, you can enhance the standard of living of the people. You can provide livelihood opportunities, right to work to the people. Please interfere. And through fundamental duties, we ensure that the idea of fraternity, which is one of the core objectives of the Constitution mentioned in the preamble, is implemented. To make it even clear, we will first look at fundamental rights. Then we will complete this chapter and then jump to DPSPs and then jump to fundamental duties. But what are these fundamental rights basically? Fundamental rights are meant to promote the ideal of political democracy. Because these fundamental rights are for the promotion of political democracy, and DPSPs are meant for the promotion of social and economic democracy. How? Let's discuss. Imagine a situation where we have an individual as the king, for example, or as the ruler, for example, or as a dictator, for example. I say, today we will discuss fundamental rights, and for the next 4 or 5 classes, we will discuss fundamental rights. Tomorrow I come and I say, we will discuss Panchayati Raj institution. But sir, you initiated a discussion on fundamental rights and now you have jumped to Panchayati Raj. So first we'll discuss Panchayati Raj. We haven't completed Panchayati Raj. I come back on Thursday and I say, today let's discuss elections. Is he mad or what? He's taking arbitrary decisions. Today saying fundamental rights, tomorrow without finishing fundamental rights, jumping to Panchayati Raj, without finishing Panchayati Raj, jumping to elections, then without completing elections, jumping to directive principles of state policy. These rules are made by men like me. Arbitrary, sometimes here, sometimes there. Can the state run like this? No. That means we need to be governed by law, not by men. And the law says, look at the schedule of these 25 classes. First, I will start with introduction. Then I will have to teach you preamble. Then I will have to teach you union and its territory. Then I have to teach you citizenship. Then I have to teach you fundamental rights. Without completing fundamental rights, I cannot jump to directive principles of state policy. So that as citizens and as students, you're aware that there is some rule book that we are following. That is fundamental rights. That's the idea behind fundamental rights. It should not be today I'm giving you equality, Tomorrow the government changes and government says, no, why do you need equality? We will discriminate you. One set of people will be given more protection as against the other. That should not happen. These fundamental rights are sacred for the growth and development of an individual. Because every individual has some potential. Don't ever consider yourself as useless. There will always be one very strong trait that you will have that defines your identity. One brilliant skill that you will have that will change your fate. The skill may be public speaking. The skill may be painting. The skill may be singing. The skill may be writing. You may become a novelist. The skill may be something else, but everybody has some potential. But how do you develop that potential? That depends on the environment in which we are living. That is why there have been movies where the protagonist is subjugated by the family. No, you have to study engineering. No, you have to take care of my business. But this protagonist, his heart lies somewhere else, or her heart lies somewhere else. Because the environment in which he or she is brought up is subjugating them. But once they come out of that environment, they explore their potential, develop their potential, and then they live happily. Every single individual has a potential, but how do you develop that potential? That requires an enabling environment. First, you should be given equality. You can also develop your potential, others can also develop their potential. Only the Brahmins are allowed to explore their potential, others are not. That should not happen, because we have to provide equality to everybody. And at the same time, we should not discriminate. All those applying for civil services examination, paper has to be single, common. There can't be one set of questions for upper castes, one set of questions for the so-called lower castes, one set of questions for Hindus, one set of questions for the other minorities. There has to be equality. There has to be non-discrimination. There has to be freedom for you to express yourself, to develop your potential. And that is why fundamental rights are important. Why are fundamental rights called fundamental? Because they are fundamental for the growth, development of an individual. Because without equality, there can be no growth. Without non-discrimination, there can be no growth. Without freedom to express yourself, there can be no growth. With exploitation, there can be no growth. So there has to be an environment of non-exploitation. All these fundamental rights become important. But these fundamental rights, they are meant for promoting political democracy. Political democracy in the sense that they are aiming to ensure the government of laws, not the government of men. The analogy that I gave you, if it was government of men, today the rule is fundamental rights. Tomorrow it is directive principle. Day after it is Panchayati Raj, without completing anything, arbitrary. But if it is government of laws, then there is some continuity. If there is government of laws, that means this is not an arbitrary action of the government. The idea is that fundamental rights, they operate as limitations on the tyranny of the executive and the arbitrary laws of the legislature. Tyranny of the executive in the sense, UPSC issues advertisements for civil services examination. Only the Brahmins and, let's say, men are allowed to appear in the civil services examination. This cannot happen. This is the tyranny of the executive. UPSC can't do that. Why? Because UPSC cannot violate fundamental rights. Because fundamental rights mean right to equality. Limitation on the executive. UPSC, you can't do that. There is a limitation. Can't violate fundamental rights. What if tomorrow legislature passes such a law? Legislature says from now onwards, civil services examination is open only for men, not for women. Can't happen. Because then you will be discriminating on the grounds of sex, which is not allowed. Because fundamental rights, which says there can be no discrimination on the ground of sex, it applies to legislature as well. Legislature, don't you dare violate fundamental rights, because these fundamental rights are limitations on you, limitations on executive. That is how we say fundamental rights are meant for promoting the idea of political democracy. These fundamental rights, or rights as we call them, what are rights? Rights are claims. What's a claim? You have submitted your fee, you have enrolled in this course, now you have a right. What is that right? You can ask me questions. That means you can claim answers from me, because that's your right, because you have paid the fee. These claims or rights can be broadly divided into two. Either these rights are constitutional rights, or these rights are statutory rights. What are the constitutional rights? All those rights which are mentioned in the Constitution. But rights can also be statutory. That means there are some rights which are not mentioned in the Constitution, but rights provided by the laws of legislature. Rights which are claims can be broadly divided into two. Either rights are constitutional rights, that means those rights which are mentioned in the Constitution, or statutory rights, that means those rights which are not mentioned in the Constitution but provided by other laws passed by the Parliament. These constitutional rights can further be divided or further be classified into two. Either rights are fundamental rights, or rights are other constitutional rights. Which are those fundamental rights? Those rights which are mentioned under Part 3 of the Constitution. Those are what we call fundamental rights. Which means fundamental rights are constitutional rights, because fundamental rights are mentioned in the Constitution. Which are these fundamental rights? There are 6 groups of fundamental rights. You don't have to mention it right now, but just keep in mind 6 groups of fundamental rights. Right to equality, dealing with Article 14 to 18. Right to freedom, Articles 19 to 22. Right against exploitation, Articles 23 and 24. Right to religious freedom, Article 25 to 28. Cultural and educational rights, Article 29 and 30. Right to constitutional remedy, Article 32. These are 6 set of fundamental rights that are mentioned in the Constitution. That means fundamental rights are constitutional rights. But there are other rights as well, which are mentioned in the Constitution, but not in Part 3. That means they are not fundamental rights. Fundamental rights are those rights which are mentioned under Part 3 of the Constitution. The 6 set of fundamental rights. But there are rights which are mentioned in the Constitution, but not under Part 3 in other parts of the Constitution. Those are what we call other constitutional rights. That means these are also constitutional rights, but other than those which are in the Part 3. Other than fundamental rights. What are the other constitutional rights? For example, right to property under Article 300 capital A is a constitutional right, but it's not a fundamental right. It is other constitutional right. Right to interstate business. You have the right to carry out business between Karnataka and Tamil Nadu, between Tamil Nadu and Andhra, between Andhra and Telangana, and vice versa. That is your right, but not mentioned in Part 3, which is a fundamental right. It's not a fundamental right. It is other constitutional right. Right to vote. Anybody who is above the age of 18 can vote in parliamentary elections, can vote in legislative assembly elections, can vote in India. Where is this right mentioned? In the Constitution. But it's not a fundamental right. It is other constitutional right. But then there are rights which are mentioned in the constitution, but within constitution, if they are mentioned under part 3, they are fundamental rights. If they are mentioned in other parts other than part 3, they are other constitutional rights. But then there are rights which are not mentioned in the constitution, but are provided by the laws passed by the legislature. For example, the right to information under the RTI Act of 2005. How is your district authority, let's say your district collector, how has he spent money which was given to him in the last 1 year? You want information on that. Can you get that information? Yes. What you have to do, you have to ask the district collector, give me the information. Where have you spent this money over the past 1 year? I need this information. And he has to provide, or she has to provide you this information. If they fail to provide this information, you can approach the State Information Commission. If they are also not helping you, then you have to apply and appear before the Central Information Commission. But this is a right which is not given to you by the Constitution. This is a right which is not given to you as a fundamental right or other constitutional right. This is a right which is given to you by the law passed by the Parliament. That law is Right to Information Act, RTI Act of 2005. MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. If you are from rural India, if you belong to the below poverty line family, 120 days of employment is your right. In some states, 100 days. In some other states, 120 days. That is your right. But this right to work under MG Narega is not your fundamental right, is not your constitutional right. This is a right which is given to you by the law passed by the Parliament, known as MG Narega, Mahatma Gandhi National Rural Employment Guarantee Act. So it becomes a statutory right. So fundamental rights which are meant to establish rule of law, which are meant to establish government by law and not government by men. Because laws are rules. Laws are there forever. Laws are there to ensure continuity and non-arbitrariness. To understand this in great detail, we need to first understand what is a right. Right is basically a claim. If this right is mentioned in the Constitution, it becomes a constitutional right. If this right is mentioned under Part 3 of the Constitution, it becomes a fundamental right. And the important thing is, if fundamental rights are violated, because fundamental rights are very important for the growth and development of an individual. You can't even wait a single day if your rights have been violated. Fundamental rights have been violated. You can directly approach the Supreme Court. If your other rights are violated, you can approach the High Court. Then approach the Supreme Court. But if your fundamental rights are violated, they are so important for the growth, development of an individual that we can't wait for long to give you your rights back. That is why Constitution says Supreme Court is the protector. Supreme Court is the guarantor of your fundamental rights. The moment your fundamental rights are violated, you can directly approach the Supreme Court. Supreme Court will issue something which we will discuss later. Supreme Court will issue some writs, and through these writs, Supreme Court will protect and guarantee your fundamental rights. That's the difference between fundamental rights and other constitutional rights. That's the difference between fundamental rights and other statutory rights. If your fundamental rights are violated, directly approach the Supreme Court. And these statutory rights are also known as legal rights. But you tell me one thing. Can we say all fundamental rights are legal rights? Can we say all fundamental rights are legal rights? Concept, common sense, which is not so common. What is a legal right? A right provided by a law. This law can be an ordinary law passed by the parliament, or this law can be the supreme law of land, which is the constitution. So all fundamental rights are legal rights. But can we say all legal rights are fundamental rights? No. Why? Because only those legal rights which are mentioned in the constitution under part 3 of the constitution, only those are fundamental rights. Because other constitutional rights, which are also legal rights, statutory rights, which are also legal rights, they are not fundamental rights. So all fundamental rights are legal rights, but all legal rights are not fundamental rights. And fundamental rights are so important for the growth, development of an individual that the moment they are violated, you can directly approach the Supreme Court without taking any route of the High Court. Clear? Done? Picture. What is the status of fundamental rights in Britain, in United States, and in India? Why we have to discuss that? Because comparison of the world constitutions is also a topic mentioned in your syllabus. And we can understand fundamental rights better when we know what is the global position. Clear? See you after the break at 7:55. See you on the other side. the United States and India. Let's look at England to begin with. In England, we say there is no code of fundamental rights. The foundation of fundamental rights in England is said to be negative. Negative in the sense that an individual has the right and freedom to take whatever action he likes, so long as he does not violate any rule of the ordinary law of land. What does that mean? In England, you will know they have an unwritten constitution. And a country where the constitution is unwritten, who is more powerful, constitution or the parliament? Who is sovereign, constitution or the parliament? It is the parliament, which is sovereign. This much is clear? 100%. Now let's look at India, for example. We have a set of fundamental rights. For example, right to equality, right against discrimination, right to freedom of speech and expression, cultural rights, educational rights. All these rights we will discuss. Only these are fundamental rights. Clear? Right to property is not a fundamental right. Right to interstate trade and commerce is not a fundamental right. Right to information is not a fundamental right. Right to work is not a fundamental right. So there is a clear-cut segregation. There are some fundamental rights, there are other rights as well. In England, we say everything is your fundamental right. Right to equality, right to freedom, right to press, right to marry, right to property, everything is a fundamental right. But the only thing is that they don't call them fundamental rights. And this right can be given by Parliament. Parliament can snatch these rights as well. In India, Parliament cannot snatch these fundamental rights. Those fundamental rights which are part of the basic structure of the Constitution. For example, the right to property previously was a fundamental right. It was deleted as a fundamental right in 1978. And I will tell you in directive principles what was the need to delete a right to property as a fundamental right. But be that as it may, there is a limitation on the powers of the Parliament. Parliament cannot delete those fundamental rights which are part of the basic structure. But there is no limitation on the power of the Parliament in Britain because they have an unwritten constitution, and in an unwritten constitution, Parliament can do anything except convert a man into a woman and a woman into a man. Let's say, for example, the right to marry. Is right to marry a right in Britain? Yes. But if the British Parliament would explicitly state that same-sex marriage is not constitutional, same-sex marriage is not allowed, then same-sex marriage is not a fundamental right in Britain. Everything else becomes a fundamental right. That means in Britain, we can say that there is no code of fundamental rights. There is no segregation that some rights are fundamental, some rights are constitutional, some rights are statutory. Everything becomes your right. An individual in Britain can do anything. And anything that he does, whether it is to write a novel, to make a movie, to publish a song, to marry, everything becomes a fundamental right, except that which the law of Britain has explicitly prohibited. You cannot murder somebody and claim it as your right because a right to murder is not a right given by the British Parliament. You cannot indulge in theft because that is not the right given to you by the British Parliament. Everything else becomes your fundamental right. And in Britain, we say courts have the fullest power to protect the individual against the executive tyranny. But the courts are powerless as against legislative aggression upon fundamental rights. What does that mean? Listen to me carefully. For example, you have right to make a movie in Britain. For example, you have a right to make a movie. How can we say this is your right? Because British Parliament has not explicitly stated that you can't make a movie. If the British Parliament has not said explicitly, clearly that you don't have right to make a movie, which means this is your right. Because in Britain, you can do anything except those things which the British Parliament has prohibited you from doing. If the British Parliament has not prohibited you from making a movie, that means right to make a movie becomes your right. What if executive, for example, the police in Britain, I'm making a movie in Britain, but the police comes and arrests me. Why have you made this movie? I will go to the court. My lord, my right has been violated. I said, what right? Right to make a movie. How do you say that is your right? Because the British Parliament has not explicitly said that you don't have the right to make a movie, which makes right to making a movie my fundamental right. And the police has arbitrarily arrested me for making a movie. The court will set me free. Said, how dare you arrest this individual? Don't you know he has a right to make a movie? Because the British Parliament has not prohibited him from making a movie. So if the executive has violated your rights, the courts will come to your rescue and protect your rights in Britain. But what if tomorrow British Parliament makes a law and says right to make a movie is not a right? There is a prohibition on you from making a movie. You cannot go to the court. My lord, British Parliament has done something, passed a law, and they're saying that you can't make a movie. Please protect me. Courts will say, I'm powerless. What can I do? British Parliament can do anything except convert a man into a woman and a woman into a man. British Parliament is sovereign. In an unwritten constitution, it is the Parliament which is sovereign, which is supreme. If the Parliament has said you don't have the right to make a movie, we are helpless. That means the British courts will protect an individual if executive has violated your rights, if the police has violated your rights, if the government has violated your rights. But the courts are helpless, powerless if these rights are snatched by the Parliament, if the legislature is snatching your rights. So long story short, we can say in Britain there is no fundamental right which is binding on the legislature in England. British Parliament can do anything. Give you the right to life, snatch your right to life as well. Give you freedom of speech and expression, snatch this right as well. Give you the right to make a movie, snatch this right as well. Give you the right to have a same-sex marriage, repeal this right as well. There is no right which is binding on the Parliament in Britain, because in Britain, Parliament is sovereign, Parliament is supreme. So fundamental rights, which are very important for the growth and development of an individual. These fundamental rights, are they present in England? We say in England there is no such thing as fundamental rights because they do not divide rights into fundamental rights, constitutional rights, other statutory rights. So that means we say the foundation of individual liberty in Britain is said to be negative. That means an individual has the liberty, has the freedom to do anything except what the legislature has prohibited. So you can do anything that the legislature has allowed you to do or not prohibited you from doing, and you can claim that all these are your rights. And if the executive, if the government, if the police is violating these rights, you can go to the court, courts will come to your rescue. But what if these rights are snatched by the legislature in England? The courts are helpless, powerless to come to your rescue because there is nothing binding on the British Parliament. Because British Parliament is sovereign, it can do anything. But when we contrast this with, you can look at the slide, there is no law in England which Parliament cannot change. That's why D. Lolme said the British Parliament can do everything except make a woman a man and a man a woman. In short, there is no right which may be said to be fundamental in the strictest sense of the term. There is no right which cannot be snatched by the British Parliament. But when it comes to the United States of America, the framers of the US Constitution, because in England, courts will protect you against the actions of the executive, against the illogical actions of the executive, against the arbitrary actions of the executive. but the courts in Britain are helpless against the legislature. But the framers of the US Constitution, which is the oldest federal constitution of the world, written constitution, the framers of the US Constitution, they wanted to protect the citizens of US from the onslaught of executive as well as the onslaught of legislature. And that is why they have something known as the Bill of Rights. A list of fundamental rights, which they call Bill of Rights. Freedom of press is explicitly mentioned in the US Constitution. And what is that freedom of press? Which means freedom from censorship. Freedom from censorship in the sense, when emergency was imposed in India in 1975, when Shrimati Indira Gandhi was the Prime Minister, any newspaper, if it was to be published, first the news items were shared with the government. Government, these are the news items that we need to publish. The government officials would look at these news items. Any line which was critical of the government was deleted, and then this copy was given to the newspapers. Now you can publish it. That is what we call censorship. That means restrictions on the press, what you can publish, what you cannot publish, what you can type, what you cannot type. This cannot happen in United States because they have freedom of press, which means freedom from censorship, which means whatever they want to publish, they can publish. That is their fundamental right. And the framers of the US Constitution said these Bill of Rights are equally binding on the legislature as well as the executive. If this freedom of press is violated by the executive, the courts will come to your rescue and protect your fundamental rights. What if tomorrow US Congress, US Parliament wants to snatch this right? The courts will come to your rescue and say, how dare you snatch this right? Because this is part of their Bill of Rights. This is fundamental to the citizens of United States. Which means in United States, they have a concept of judicial supremacy as against parliamentary supremacy. Which means any law which is passed by the US Congress, US Parliament, if it violates these Bill of Rights, if it violates these fundamental rights, you can go to the court and the court will come to your rescue. Whether executive is violating your fundamental rights or legislature is violating your fundamental rights, you don't need to worry because you are the citizen of United States, and in United States we have a judicial supremacy, which means the US courts will come to your rescue and protect your fundamental rights against the onslaught of legislature, against the onslaught of executive as well. Similarly, when it comes to India, our constitution follows the American model rather than the British model. But the powers of judiciary vis-a-vis legislature are weaker in India than in United States. How? Listen to me carefully. We have a list of fundamental rights. Can these fundamental rights be violated by executive? No. Can these fundamental rights be violated by legislature? No. If they are violated, you can approach the Supreme Court. Supreme Court will come to your rescue, protect your fundamental rights. But in India, fundamental rights are not absolute. Listen to me carefully, very important point. Fundamental rights are not absolute. What do we mean by absolute nature of fundamental rights? Which means there are restrictions which are known as reasonable restrictions. What are these reasonable restrictions? For example, we have a fundamental right, Article 19(1)(a), which is known as freedom of speech and expression, which we will discuss on Thursday possibly or Friday. which means you have the freedom to say whatever you want to say. You have the freedom to express whatever you want to express. You have the freedom to write whatever you want to write. But this right is not absolute. That means it doesn't mean you can write whatever you want to write. There are some restrictions. Restrictions such as public order. What does that mean? One classic example. We are watching a movie in a multiplex. Let's say it's the new Shah Rukh Khan starrer Jawan or Pathan, which is the latest movie, Pathan or Jawan, whatever Nan, we're watching that movie. And suddenly I'm having popcorn as well, and I start shouting, fire, fire, fire. What will happen in the multiplex? There will be stampede. People will start rushing towards the exit. Ultimately, there will be stampede. People will come on each other. Some will be without any breath, and ultimately some people may die as well. I'm sitting very calmly on my seat, having popcorn and a glass of Pepsi or Coke or whatever, and I see all this ruckus going on. Then the police comes, and police starts arresting me. But why are you arresting me? Why did you cry fire, fire, fire where there was none? Don't you know through your actions it has led to the death, unfortunate deaths of 20 people? 30 people have been injured. The multiplex has suffered a loss. There is a chaos because of your utterance, because of what you cried, fire, fire, fire. I would say, look at the Constitution. Article 19(1)(a), freedom of speech and expression. I spoke fire, fire, fire. I expressed because that's my freedom. The police will have a slap against me and said, how dare you? Don't you know this right is not absolute? There are restrictions. Through your freedom of speech and expression, you cannot violate public order. Tomorrow you will say, let's raise arms, AK-47, and kill these politicians. You can't say that because you are then instigating people to violence. You can write whatever you want to write. You can express whatever you want to express. You can say whatever you want to say. Sing an Arijit Singh song. Why do you want to cry fire, fire, fire where there is none? Ask people to fight corruption. Why are you asking people to kill the politicians? You're inciting people to violence. So this right of freedom of speech and expression is not absolute. There are restrictions, and those restrictions are known as reasonable restrictions. But who can impose these reasonable restrictions in India? Parliament. Initially, when the Constitution was enacted, there were 4 grounds on the basis of which your freedom of speech and expression can be restricted, which we will discuss later. 4 additional grounds were mentioned when the Parliament amended the Constitution. That means 4 additional reasonable restrictions were imposed on your fundamental rights. By whom? By the Parliament. But in United States, if there is a restriction on your Bill of Rights, if there is a restriction on your fundamental rights, those restrictions cannot be imposed by the Parliament. Those restrictions can be imposed by judiciary. Judiciary can impose restrictions on your fundamental rights, not the US Congress, not the US Parliament. But in India, we say we have a list of fundamental rights. These fundamental rights are equally binding on executive, equally binding on legislature as well. Neither the executive nor the legislature can violate these fundamental rights. But if there are restrictions to be imposed on fundamental rights, those restrictions can be imposed by the legislature, by the Parliament, not the judiciary. But in US, it's the reverse. Restrictions on your fundamental rights can be imposed by judiciary, not by the Parliament. That is why we say in India, the powers of judiciary vis-a-vis, with respect to legislature, are weaker in India than the United States. And that is why this paragraph, while the declarations in the American Bill of Rights are absolute, that means the freedom of speech and expression in United States is absolute. Say whatever you want to say. They can even burn their national flag. They can even use their national flag as an undergarment, which is something that cannot happen in India. Because if you do that, you will be punished for violating the Protection of National Honor Act. So that means the Bill of Rights are absolute in United States. And the power of the state to impose restrictions upon these fundamental rights have to be evolved by the judiciary. The judiciary can evolve these restrictions, can impose these restrictions. While in India, this power has been expressly conferred upon the legislature by the Constitution itself. Constitution itself says if there are restrictions to be imposed on fundamental rights, those can be imposed by the Parliament. But there is still a power given to the judiciary in India, and that power is known as judicial review. So Constitution, listen to me carefully, Constitution has given the power to the Parliament of India that you can impose reasonable restrictions on fundamental rights. What if restrictions are imposed by the Parliament? Restrictions can be imposed by the Parliament. Restrictions can be imposed by the Parliament alone. But are these restrictions reasonable or not? That the judiciary will decide in India through its power known as the judicial review, where the judiciary will review the laws passed by the Parliament to see whether those restrictions which have been imposed on fundamental rights, whether those are reasonable or unreasonable, just or unjust, fair or unfair. Long story short, we are discussing a chapter known as fundamental rights. But fundamental rights, DPSP's fundamental duties. Although these are different parts, distinct units, part 3, part 4, capital A, yet when we look at them together, we say that they are used to concretize, to give shape to the lofty goals of justice, liberty, equality, fraternity, dignity, which are mentioned in the preamble to the Indian Constitution. And fundamental rights basically are negative obligations, restrictions on the powers of the state. State, don't interfere with the life and liberty of an individual. State, don't discriminate. State, don't deny equality. State, don't deny and deprive an individual of his right to life and personal liberty. Don't do this, don't do that. What are these? Limitations, restrictions, negative obligations on the state. But are there fundamental rights present in other countries as well, in the constitutions of other countries? Yes. When we compare it with England, because we have borrowed a lot of provisions from England, and when we compare it with the US, because we also claim ours is a federal constitution, just like United States of America, when we compare our fundamental rights with these countries, we see that there is a commonality, there is a difference as well. In England, there is no segregation of rights into fundamental rights, constitutional rights, other statutory rights. In Britain, you can do anything, and everything is your fundamental right, except those things which the Parliament of Britain has prohibited you from doing. Because British Parliament, in an unwritten constitution, is sovereign, it can do anything. But in United States, there is Bill of Rights. But can restrictions be imposed on these rights? That is for the judiciary to decide and evolve, not the legislature. And these Bill of Rights are absolute, without restrictions. No restrictions imposed by the legislature. If at all restrictions are to be imposed, can be imposed by the judiciary. In India also, we say that there is a list of fundamental rights. Neither the executive nor legislature can violate these fundamental rights. But these fundamental rights are not absolute. And if restrictions are to be imposed which are reasonable on these fundamental rights, that can be done only by the Parliament. With the power of judiciary, that they have a judicial review. They can review this law passed by the Parliament to see if this reasonable restriction was indeed reasonable, if this restriction was just, if this restriction was fair. That is the difference between the three countries. Any questions as of now? What is a convention? Convention is an unwritten rule, not mentioned anywhere, but something that we follow. Sir, why is it that some rights are exclusively available to citizens but not to aliens? We will discuss that today. No question, crystal clear, all clear. In India, there is a mix of judicial supremacy and the parliamentary supremacy. In a sense, yes, parliament can impose restrictions with the power of judiciary to decide whether these restrictions are reasonable or not. But if you want to understand it deeply, for that you will have to discuss this chapter, judiciary. There we will have a clear picture, and there we will conclusively prove that in India, judiciary is more powerful as against any other institution. Why it is different for armed forces and paramilitary forces? We'll discuss. Fundamental rights are not absolute, there are restrictions, exceptions. Let's explain all these fundamental rights one by one. First, we will talk about Article 12. And what is Article 12? Throughout this chapter of fundamental rights, you would come across this term known as the state. The state shall not deny equality before law. The state shall not discriminate. The state shall not discriminate against the citizens only on the grounds of religion, race, caste, sex, place of birth. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this, the state shall not do that. Who is this state? Against which your fundamental rights are enforced. Who is this state? If it violates your fundamental rights, you can go and knock the doors of the Supreme Court directly. Who is the state against which your fundamental rights are enforced? The definition of that state is given under Article 12. And Article 12 talks about the state includes, so that you are not confused with that, is this the state of Karnataka or is this the state of Madhya Pradesh or is this some other state? What is this term state which is mentioned in the fundamental rights chapter against which your fundamental rights are enforced? Which means if this state is violating your fundamental rights, you can drag the state to the court. Article 12 says the state includes the government and parliament of India. Which means if the Prime Minister and his ministers and the members of the bureaucracy who are part of the government, if the parliament, which is Lok Sabha, Rajya Sabha, president, if they violate your fundamental rights, drag them to the court. State also includes the government and legislature of all the states in India. Whether it is the Chief Minister of Karnataka or the Legislative Assembly of Karnataka, whether it is the Chief Minister, the government, the bureaucrats of UP led by the Yogi, or it is the legislature of Uttar Pradesh which is violating your fundamental rights, drag them to the court. Or all the local authorities, even if it's a Panchayati Raj institution, even it's a municipality, it is also under this definition state. If they violate your fundamental rights, drag them to the court. But the Constitution under Article 12 talks about something else. It talks about other authorities within the territory of India or under the control of the government of India. Article 12 talks about the definition of state. State in the sense, Constitution says throughout this chapter of fundamental rights, state cannot do this, state cannot do that, state can do this, state cannot do that. Who is the state which cannot interfere with your liberty, which cannot snatch your fundamental rights? Article 12 explains that in the definition of state, saying state means government of India and parliament of India, government of state and legislature of the state, local authorities, Panchayati Raj institutions, municipalities. Article 12 also says other authorities. other authorities within the territory of India or under the control of the government of India. Which are these other authorities? Not mentioned in the constitution. But who is the final interpreter of the constitution? Who is the final interpreter of the constitution? Very good. The answer is Supreme Court. That is why in the first class I gave you the definition of a constitution. After all, what is a constitution? Constitution is what the Supreme Court tells us it is. That is the constitution. And constitution, what it is, these other authorities, Supreme Court in various judgments have now explained which are these other authorities which also cannot violate your fundamental rights. Because Constitution says under Article 12, state includes the Government of India, Parliament of India, Government of State, Legislature of State, local authorities, Panchayati Raj and municipalities, and other authorities. Which are these other authorities? Supreme Court says, number one, that authority whose financial resources, where the state is the chief funding source, that means the entire share capital is held by the government. If there is an organization, if there is a company where the entire control of that company is with the government, where the financial resources of the government are given to that entity, State Bank of India is a state. Reserve Bank of India is a state. Life Insurance Corporation of India is a state. Why? Because the principal source of funding for these institutions is the government. Majority stake in these organizations is with the government. It is a state. Which means even State Bank of India cannot violate your fundamental rights. Life Insurance Corporation cannot violate your fundamental rights. Reserve Bank of India cannot violate your fundamental rights. Or other authority means deep and pervasive control of the state. Where the state has deep control over such institutions. For example, Food Corporation of India. Where the state has deep control. For example, the railways. Where the state has deep control over railways. In fact, the state, we can say, enjoys some sort of control over railways, that it operates railways throughout the country. It is also a state, and the state cannot violate your fundamental rights. The functional character being governmental in its essence, meaning thereby that its functions have public importance and are of governmental character. What is the role of the government? To provide electricity to the people. What is the role of government? To provide healthcare facilities to the people. So government hospitals come under state. The electricity boards come under state. The pollution control boards come under state. All these entities whose primary function is governmental in character, they are also within the definition of the state. A department of the government which is transferred to a corporation. For example, previously we used to have Doordarshan, All India Radio. We still have, but those were government departments. One government department was Doordarshan. One government department was All India Radio. Later on, both these entities, Doordarshan as well as All India Radio, they were transferred to a corporation, and that corporation was known as Prasar Bharati. Prasar Bharati Corporation. Prasar Bharati becomes a state. Our public sector undertakings become a state. Steel Authority of India Limited, Coal India. All these are public sector undertakings where the state is the chief source of funding, or the state controls the majority of the stake. All these are states. Or the state enjoys monopoly status. Any entity which enjoys monopoly status becomes a state. Monopoly in the sense, Indian Railways. Can any other entity run railways in India? No. Department of Atomic Energy. Only this department has the power, has the monopoly, complete control over atomic resources in India. Can a private entity in India make an atomic bomb? No. Can a private startup in India manufacture a nuclear weapon? No, because this is the monopoly of the state. All those entities which deal with manufacturing these atomic bombs or hydrogen bombs or these nuclear weapons, they come under state, and the state cannot violate your fundamental rights. This is the only thing that you should keep in mind, because after that it becomes so technical that you would be confused. After that it becomes so technical that you will become the lawyer of the Supreme Court, which ultimately is of no value whatsoever. For example, BCCI, Board of Control for Cricket in India. The Indian cricket team is basically not an Indian cricket team. It is the cricket team of BCCI, Board of Control for Cricket in India. And it enjoys a monopoly status. Monopoly status in the sense, can any other organization in India select an Indian cricket team except BCCI? No. Can any other entity in India organize official matches in India other than BCCI? No. Can any other entity operate or start a league such as the Indian Premier League in India except the BCCI? Yes and no. Yes in the sense no. No in the sense, there was a time when Zee launched its own Premier League, which was even before the Indian Premier League was started in 2007 or 8. In fact, matter went to the court. Zee Telefilms versus BCCI. BCCI had to award contract to broadcasters who would broadcast Indian cricket matches or those matches which will be played in India. Zee Telefilms was also a bidder. Zee Sports. Star was also a bidder. Other channels were also bidders. They wanted to bid for the broadcast rights. Ultimately, Zee lost this bid. Zee approached the court and said BCCI has violated equality principle, justice principle, which is violative of fundamental rights. And as such, we're taking BCCI to the court. Now, the principal thing that the court had to decide now was to see if the BCCI is a state or not. Because in all this definition, what if tomorrow Byju's as an entity violates your fundamental rights? I have the freedom of speech and expression, you will claim. But I will mute you. I will not let you ask the question. I will block your questions. Can you claim that my freedom of speech and expression has been violated? Yes, you can. But can you approach the Supreme Court for that? No. Why? Because Byju's is not a state within the meaning of Article 12. Only the state, if it violates your fundamental rights, you can drag the state to the court. Others can violate your fundamental rights. For example, this is the government property or government accommodation. For example, now the government has to give this accommodation to the people so that people can stay. Can the government say that this accommodation is available only for those who are Hindus? No, because the state is then discriminating on the grounds of religion, which the state cannot do. But if this is not the government accommodation, this is my accommodation. This is my private property. Can I say that I want to rent this property only to Hindus and not Muslims? I can do that. Am I discriminating on the grounds of religion? Yes, I am. But am I violating your fundamental rights? No, because I am not a state. If the state is violating your fundamental rights, you can drag the state to the court. Others, you cannot. Now, if BCCI has violated fundamental rights, first thing that the court had to decide was whether BCCI is a state or not. Because what is a state? Government of India, Parliament of India, Government of State, Legislature of State, Panchayati Raj institutions, Indian embassies outside India as well, or other authorities. Which are these other authorities? One such other authority is an entity which enjoys a monopoly status. Z Telefilm said, BCCI enjoys monopoly. That means it's a state. And as a state, it cannot violate fundamental rights. But BCCI convinced the judiciary. BCCI convinced the judiciary by saying that although we enjoy monopoly status, but this monopoly status is not conferred by the state. If railways enjoy monopoly status, that status is conferred to railways by the state. The state has not conferred monopoly on BCCI. So when the state has not conferred monopoly on BCCI, BCCI is not a state within the meaning of Article 12. And as such, BCCI is not a state within the meaning of Article 12, under Article 12 of the Constitution. Indian Space Research Organization is a state. It cannot violate your fundamental rights. But you don't have to go too deep into the technicality because we will then lose the scope of this exam. You just have to keep in mind that when the state term is used in fundamental rights, who is the state that is mentioned in Article 12? And who is the state? The Government of India, the Government of State, Parliament of India, Legislature of State, Indian embassies outside India, local governments, Panchayati Raj institutions, municipalities, those entities which are sufficiently funded by the government, for example, public sector undertakings, those entities, those departments of the government which are transferred to a corporation, for example, Prasar Bharati, and those entities which enjoy monopoly status. But that monopoly status should either be conferred by the state or should either be protected by the state. And if this state is violating your fundamental rights, you can drag the state to the court because the court will come to your rescue, protect, and safeguard your fundamental rights. Is that clear? What about Legislature of Delhi and Puducherry? They are also state within the meaning of Article 12. Is judiciary included in the term state? That's a very good question. Listen to me carefully. Who comes to your rescue when your fundamental rights are violated? Judiciary. So an entity which comes to your rescue when your fundamental rights are violated, it is inconceivable, unthinkable to think that the entity which is meant to protect your fundamental rights is itself capable of violating your fundamental rights. That is why judiciary is not part of the state. Because judiciary is meant to protect your fundamental rights. And as a protector of your fundamental rights, can judiciary also be included in this term state? No. Why? Because an entity which is meant to protect, safeguard your fundamental rights, how can we even think that such an entity which is meant to protect your fundamental rights is itself capable of violating your fundamental rights? But then over a period of time, things have evolved. Evolved in the sense we say judiciary has two roles. Administrative role and judicial role. Administrative role in the sense judiciary, its various parts, they're allocating cases to different judges. Members of the judiciary, they have property as well. On the administrative side, if they violate fundamental rights, they are part of the state. But on the judicial side, when they give judgments, you can't say that this judgment that you have given is violating my fundamental rights. I will drag you to the court again. So judiciary today plays two important roles. On the administrative side as well, how the cases are allocated. Allocated in the sense there is something known as master of the roster. Who is the master of the roster? Chief Justice of India. What does that mean? For example, at Byju's, we have this live online classroom program. I get to teach polity. Who gets to teach geography? I will decide it. For example, who gets to teach economics? I will decide it. Who gets to be your subject matter expert? I will decide it. So I become master of the roster. That means I allocate responsibilities to the individual teachers. I allocate responsibilities to the individual subject matter experts. I allocate responsibilities to various individuals who are developing and preparing content for this exam. Similarly, Chief Justice of India is the master of the roster in the Supreme Court. A case related to tax will be heard by which judge? That Chief Justice will decide. A case related to elections will be heard by which judge? That Chief Justice will decide. A case related to, let's say, corruption, a case related to land acquisition, a case related to constitutional matter, a case related to fundamental rights. Who are these judges who will get to hear these cases? That Chief Justice will decide. So Chief Justice is the master of the roster. He manages the roster. Who are these judges who will hear what sort of cases? That is the administrative side of the judiciary. There, if I do something violating fundamental rights, I am part of the state, I can be held accountable. But when I'm really hearing a case, I'm giving a judgment in Article 370 case, or in citizenship amendment case, or in EWS reservation case, I am not under the state because I am incapable of violating your rights. Because I am meant to protect your fundamental rights. That is why we say judiciary is not part of the state. But only on the administrative side, judiciary is part of the state. Is that clear? Clear. Okay. Now let's look at Article 13 of the Constitution. Laws inconsistent with or in derogation of the fundamental rights. There are 4 clauses under Article 13. Clause 1, 2, 3, 4. We'll discuss all the clauses, but you don't have to remember it clause by clause. Just understand the concept. What is Article 13? Article 13, Clause 1. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. What does that mean? I'll give you an example. When was the Constitution enacted? 26th January 1950. Because it was on this date that this chapter, Fundamental Rights, under Part 3 of the Constitution also got enforced. But when the Constitution was implemented, even before the Constitution was implemented, there were some laws which were already present. For example, Criminal Procedure Code. For example, Civil Procedure Code. For example, Indian Penal Code. Which now the government is trying to replace with the different set of codes, which we will also discuss. So Indian Penal Code, which was implemented in 1860. What is this Indian Penal Code? It's a set of laws. Set of laws in the sense, it provides, lists down punishment for all the offenses. Section 302 is for murder. Section 376 is for rape. Section 103 is for something else. That means for every crime, there is a punishment provided. And that is mentioned where? In Indian Penal Code. But what is Indian Penal Code? It is a law which was in force in the territory of India immediately before the commencement of the Constitution. Now, once the Constitution has been enacted, once this chapter fundamental rights has been provided, once all these fundamental rights under Part 3 have been provided, whether these laws will continue after 26 January 1950 as well or not. That's what Article 13 Clause 1 says. If there is a law which was in force in the territory of India immediately before the commencement of the Constitution, and now the Constitution has been enacted, once fundamental rights have been provided, can these laws continue after 26 January as well? Yes, if these laws are in agreement with fundamental rights. But if these laws violate fundamental rights, those laws cannot continue. And this is where we talk about a concept known as doctrine of severability. And what is that? Let me discuss. Yesterday, I gave you an example of Section 377 of Indian Penal Code, which talked about unnatural offenses. All those unnatural offenses which are against the order of nature. This was primarily used to target homosexuals or homosexuality, incest, bestiality, for example. Homosexuality, sex between men and men, sex between women and women, what is primarily known as the members belonging to LGBTQ community. It's an unnatural offense, or it was considered as unnatural offense against the order of nature, because that's not how the nature has created you. That's what the previous logic was. Incest, brother having sex with sister, mother having sex with son, father having sex with daughter, incestuous relationship. And this is no wonder that in European societies now incest is at its peak. It's considered against the order of nature because that's not how you do it. Bestiality, sex with animals, sex with dogs, donkeys, for example, horses, your pets. It is against the order of nature. It's a carnal intercourse against the order of nature, and as such, it is an offense. So this Section 377 of Indian Penal Code, which was a law immediately prior to the commencement of the Constitution, can this law continue after the commencement of the Constitution? Yes. Yes, yes, yes. But the moment it violates fundamental rights, this law shall, to the extent of such inconsistency, be void. In 2017-18, Supreme Court in Navte Johar judgment said, homosexuality is not a crime. Right to love is also a fundamental right, regardless of the gender of your lover. So same-sex relationship is constitutional. Why? Because this section 377, insofar as it criminalizes homosexuality, it violates some fundamental rights which are provided under Part 3 of the Constitution. For example, Article 14, which deals with equality. Article 15, which talks about non-discrimination on the grounds of sex, which includes sexual orientation. Article 21, which talks about right to life and dignity. All these fundamental rights are violated, which means the section 377 is not continuing. But do you know section 377 still exists? Why? Because incest is still a crime. Bestiality is still a crime. That means we say this is doctrine of severability. That means if there is a law which has 10 clauses, 10 sections, if only 5 clauses are violating fundamental rights, only these 5 clauses will be cut. Only these 5 clauses will not operate. The remaining 5 clauses will continue. That means you are severing, you are cutting only those clauses, only those parts which violate fundamental rights. Remaining sections continue, remaining laws continue. Which means section 377, if somebody would tell you has been declared unconstitutional, it is wrong. Section 377 was not declared unconstitutional. Section 377 was read down. And what is that read down or reading down of a particular law? One part of it is unconstitutional, remaining continues. So we are reading down this law to say homosexuality is not a crime, but bestiality is still a crime, incest is still a crime. That is what we call doctrine of severability, and that is Article 13, Clause 1. Long story short, this is 26 January 1950. This is when the Constitution was enacted. This is when the fundamental rights were provided. This is the set of fundamental rights provided. Prior to the commencement of the Constitution, there were various laws. Indian Penal Code, Criminal Procedure, Civil Procedure, so many other laws. Can these laws continue after the commencement of the Constitution as well? Yes, provided these laws are in agreement with the fundamental rights. The moment these laws violate fundamental rights, those laws will be declared unconstitutional. But that does not mean the entire law will be declared unconstitutional. To the extent of inconsistency, this is where doctrine of severability comes into picture. Only those aspects of those laws which violate fundamental rights, those aspects would be read down. The remaining laws can continue. It is not that section 377, which criminalized homosexuality, it was read down by the judiciary. That means the entire Indian Penal Code goes. No, the other Indian Penal Code parts, they continue. Only section 377 was read down. That is Article 13, Clause 1. All laws enforced in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. That's Article 13, Clause 1. Any questions? Very good. Number 2, the state shall not make any law. And you know what is a state? Definition provided under Article 12. The state shall not make any law which takes away or abridges the rights conferred by this part, And any law made in contravention of this clause shall, to the extent of such contravention, be void. Judicial review, which we will discuss in great detail in judiciary, which basically means the power of the judiciary to review the laws passed by the parliament or the actions and the acts of the executive. This power of the judiciary that it can review is not mentioned anywhere in the constitution. Nowhere is this term judicial review mentioned. Nowhere is even this power mentioned. But we can trace this concept of judicial review to Article 13 of the Constitution, to Article 13, Clause 1 of the Constitution. How can we trace it? All laws which are in force in this country immediately prior to the commencement of the Constitution, if these laws violate fundamental rights, these laws will be declared void. And the logic is, who will declare them void? Judiciary, which means judiciary has the power of judicial review. Although not mentioned directly, but we can trace this concept. Similarly, Article 13, Clause 2, state cannot make any law. When we say any law, it cannot make any law. And through this law, what it cannot do, it cannot delete a fundamental right. It cannot abridge a fundamental right, which means it cannot modify a fundamental right. And if Parliament does this, if Parliament passes a law deleting a fundamental right, if Parliament passes a law modifying a fundamental right, that will be declared void. By whom? By the judiciary, which means judiciary has the power of judicial review. Because who is the final interpreter of the Constitution? Judiciary. But if the state cannot make any law, what is the definition of this law? When we say the state cannot do this, state cannot do that, what is the definition of that state? The definition is provided under Article 12. When we say the state cannot make any law, what is that law? That is provided under Article 13, Clause 3. Article 13, Clause 3 explains what is this law. Article 13, Clause 3 says, law means ordinance issued by the President, which we will discuss later. Ordinance, order, bylaw, custom, usage, all these are part of laws. And through all these things, you cannot delete, you cannot modify, you cannot abridge a fundamental right. Then came something else. What happened? Madras government, immediately after the commencement of the Constitution in 1951, what it did, it issued an order. Through this order, what it did, it provided reservation for SCs and STs in government, engineering, and medical colleges. Madras government said, we'll issue an order. Through this order, what we will do, we will reserve seats for SCs and STs in government, engineering, and medical colleges. Matter went to the court, Supreme Court. Champak Dorai Rajan versus State of Madras. The petitioner Champak Dorai Rajan said, "My lord, I have an issue." Said, "What is the issue?" "Sir, my fundamental rights have been violated." "How?" "Sir, Madras government says there will be reservation of seats in government engineering and medical colleges for SCs and STs. Said, "So?" "Sir, it violates Article 15. How? Because Article 15 prohibits discrimination on the grounds of caste. There can be no discrimination. The state cannot discriminate against its citizens only on the grounds of caste. But here the state, which is the Madras government, has issued an order and through which it is discriminating against the citizens only on the grounds of caste. That is why it violates my fundamental rights. My lord, please protect me." Why? Because Article 13 Clause 2 gives you the power. Because the state shall not make any law to delete a fundamental right, to modify a fundamental right. Supreme Court said, yes, you're right. Madras government, this order is unconstitutional because you're discriminating against the citizens only on the grounds of caste. The government said, what do we do now? Central government said, what do we do now? We need to provide reservation to SCs and STs, which was not originally mentioned in the constitution. Political reservation was mentioned. That means reservation of seats for SCs and STs in Lok Sabha assemblies. It was part of the original constitution. Reservation in jobs for SCs and STs, it was also mentioned in the original constitution. But reservation for SCs and STs in engineering colleges, medical colleges, in educational institutions was not mentioned. Parliament got together, amended the constitution. First Constitutional Amendment Act, 1951. Article 15 was amended. Article 15, Clause 4 was added to the Constitution. And it is this Article 15, Clause 4, which provides for reservation for those who are socially and educationally backward in educational institutions. Matter went to the court again. My lord, I have a question. I said, what's the question? Sir, Parliament has passed a law. And through this law, it has modified a fundamental right. Modified Article 15 of the Constitution. But my lord, Article 13 Clause 2 explicitly states, state cannot make any law. State includes Parliament of India. Which means Parliament cannot make any law to modify, to abridge fundamental rights. This time the Parliament has abridged, modified fundamental rights under Article 15 of the Constitution. Supreme Court asked the government, come here. What are you doing? Sir, we have amended Article 15, which is part of fundamental rights. Yes, sir. But Article 13 Clause 2 does not allow you to modify a fundamental right. No, sir, I think it does allow. Sir, how? Sir, it's about interpretation. How? Sir, look at what Article 13 Clause 2 says. What does it say? Sir, it says state cannot make any law. Sir, right, that's what you are doing. You have passed a law. Sir, law is different. Constitutional Amendment Act is different. Because the definition of what is a law is mentioned in Article 13 Clause 3 itself. Through an ordinary law, we cannot delete a fundamental right. Through an ordinary law, we cannot modify a fundamental right. That means through ordinance, through order, through bylaw, through rule, through regulation, through notification, through custom, through usage, We cannot modify, abridge, delete a fundamental right. But sir, please look at Article 13, Clause 3. Is there any mention of a Constitutional Amendment Act? Does the Constitution anywhere mention that law means Constitutional Amendment Act as well? That means even through Constitutional Amendment Act, you cannot delete, modify, abridge a fundamental right. It does not. That means Constitution has clearly differentiated between an ordinary law and a Constitutional Amendment Act. Through an ordinary law, we know we cannot delete, modify, abridge a fundamental right, but only through a Constitutional Amendment Act passed under Article 368. Because a Constitutional Amendment Act is passed under Article 368 of the Constitution. Through this, we can delete, modify, abridge a fundamental right. Because when Constitution says you cannot pass any law, the definition itself is given. But this definition does not include a Constitutional Amendment Act. That means through Constitutional Amendment Act, which is not a law, which is not an ordinary law, we can delete, modify, abridge fundamental right. Supreme Court said, yes, you are right. Law is different. That means all these are part of law. Through these, through ordinance, through bylaw, through custom, through usage, through notification, you cannot delete, modify, abridge a fundamental right. But Constitutional Amendment Act is different altogether. Through this, you can delete, modify, abridge a fundamental right. This case was known as Shankari Prasad versus Union of India. A decade and a half later, Golaknath versus State of Punjab, 1967. It's all about interpretation. Supreme Court said in Golaknath versus State of Punjab, law in Article 13, Clause 2 includes a Constitutional Amendment Act. That means even through a Constitutional Amendment Act, you cannot delete, you cannot modify, you cannot abridge a fundamental right. The government asked the Supreme Court, but sir, in 1951, in Shankari Prasad case, you said law is different, Constitutional Amendment Act is different. Through an ordinary law, you cannot delete, modify, abridge a fundamental right. But through a Constitutional Amendment Act, you can delete, modify, abridge a fundamental right. Golaknath case, Supreme Court is saying, no, that's not the correct position. It's about interpretation. Sir, how can you say, even through a Constitutional Amendment Act, you cannot delete, modify, abridge a fundamental right? Supreme Court said, look at Article 13, Clause 2. State cannot pass any law. And when it is any law means rules, orders, bylaws, customs, usages, ordinances, Constitutional Amendment Acts as well. So through Constitutional Amendment Act also, you cannot delete, modify, abridge a fundamental right. Sir, what are you saying? I'm saying fundamental rights are beyond your amending powers. Don't you dare cast an evil eye on fundamental rights. Fundamental rights cannot be deleted, cannot be modified, cannot be abridged. You don't have that power. The government asked the Supreme Court then, sir, there is Article 368, which gives power to the Parliament to amend the Constitution. Supreme Court said, no, I don't think so. Sir, how can you say that it doesn't give the power? The procedure is mentioned in Article 368. Said, what is that procedure? Sir, it says the bill can be introduced in Parliament. in either Lok Sabha or Rajya Sabha, then it should be passed by special majority. If it affects the federal features, we need the ratification by half of the states as well. All this procedure is mentioned. That means this procedure has to be followed by Parliament while amending the Constitution. So how can you say Parliament does not have the power to amend the Constitution? Supreme Court said, look at Article 368, which you are quoting, and look at the title of Article 368. Article 368's title is Procedure for Amendment. Procedure for Amendment. Where is it mentioned in Article 368 that it is the power of the Parliament to amend the Constitution? It only talks about procedure. Said, sir, yes, it talks about only procedure, but procedure for us, Parliament. Otherwise, who will follow this procedure to amend the Constitution? Supreme Court said, we don't know. Maybe you should set up another Constituent Assembly. Another Constituent Assembly, just like it was set up in 1946, which remained in force till 1949, which drafted the Constitution. You can set up a similar Constituent Assembly. And that Constituent Assembly will follow the procedure mentioned in Article 368 to amend the Constitution, to modify the Constitution. You don't have that power. You only have an ordinary legislative power. You can only pass ordinary laws. Constitution, once it is done, it is done. You can pass an ordinary law. You don't have the power to amend fundamental rights. Indira Gandhi was the Prime Minister. She got the Parliament together, said, let's amend the Constitution again. But Madam Gandhi, this will be challenged in the court. So what? We will defend it. Madam Gandhi, what will we do? Let's first amend Article 368. Why, ma'am? Because what did the Supreme Court say? That the title of Article 368 is Procedure for Amendment. Let's change the title of Article 368. How, ma'am? We will revisit this and we will call Article 368 with the title Power of Parliament. To amend the Constitution and the procedure therefore. Supreme Court said you don't have the power to amend the Constitution because that is not mentioned in the title. We changed the title itself. Title says power of the Parliament to amend the Constitution and the procedure thereof. Madam, that's okay, but Article 13, which says state cannot pass any law to modify, delete, abridge fundamental rights. Said, don't worry, we will add a clause to Article 13. Madam, what would that clause be? Article 13, Clause 4, inserted by the 24th Constitutional Amendment Act, 1971. Nothing in this article shall apply to any amendment of the Constitution made under Article 368. Nothing in this article, because in this article it is mentioned that Parliament cannot make any law to delete, modify, abridge a fundamental right. This will not apply. This restriction will not apply to the law made by the Parliament under Article 368. To the amendment of the Constitution made under Article 368. That means through a Constitutional Amendment Act, Parliament can delete, modify, abridge a fundamental right. Not through an ordinary law, but through a Constitutional Amendment Act. Even this was challenged before the court. In a famous case, which we will discuss in great detail next week, Keshavananda Bharti versus State of Kerala, 1973. The Supreme Court said, yes, you are right. Law is different. Constitutional Amendment Act is different. Through an ordinary law, which is ordinance, act, rule, custom, usage, notification, regulation, through these you cannot delete, modify, abridge a fundamental right. But only through a Constitutional Amendment Act passed under Article 368, which requires a tougher majority. Through this, you can delete, modify, abridge a fundamental right. But only those fundamental rights which are not part of the basic structure. There are some fundamental rights which are part of the basic structure, which we will discuss later. Those you cannot even touch, modify, abridge, even using Article 368. So long story short, Article 12 talks about the definition of the state, that the state against which your fundamental rights are enforced. Which are these entities of the state? That's mentioned under Article 12. And Article 13 talks about four things. Number one, when this constitution was enacted, when the chapter fundamental rights was provided, prior to that there may be laws which are enforced within the territory of India. If those laws are in agreement with fundamental rights, those laws will continue after the commencement of the constitution as well. But the moment these laws conflict with fundamental rights, are in contravention of fundamental rights, those laws will not continue. But only those clauses of that law which violate fundamental rights, the rest of the law will continue. Doctrine of severability. Sever only those parts, cut only those parts which violate the fundamental rights. And Parliament has the power to modify a fundamental right, to abridge a fundamental right, to delete a fundamental right. But only those rights which are not part of the basic structure. But Parliament can do that only through a Constitutional Amendment Act passed under Article 368, not through an ordinary law, and clearly not through an ordinance, order, bylaw, custom, usage, rules, notifications, regulations, so on and so forth. That is Article 13 of the Constitution. Any questions as of now? Section 124 capital A violates fundamental rights. How can this law survive in the IPC? That is your assumption. The Supreme Court has said sedition does not violate fundamental rights. In Kedarnath Singh case, in Shreya Singhal case, in so many cases. But right now it is under review. That's a different story. We will discuss this in fundamental rights chapter. But as of now, it does not violate fundamental rights. Section 377 is still enforced. Then this isn't contrary to the judgment of homosexuality, because incest is also the act of mutual consent. If homosexuality is natural, then incest is also natural. You may be right, but courts can only decide on matters which are presented to it. Clear? Nobody argued that even incest should be allowed. When no petitioner argued before the court that please allow incest as well apart from homosexuality, how can Supreme Court randomly say that even incest is allowed? Although you're right, it involves consent. If in homosexuality there is consent of two parties, some people may find it horrible. How can you have a lesbian or gay relationship? But if two adults are in a consensual relationship, as a society, we should not interfere. Similarly, if brother and sister are in a consensual relationship, even if you find it horrible, as a society, we should not interfere because these are two adults in a consensual relationship. But bestiality can never be allowed. Why? Not that I am pro animals, but I'm pro consent. Animals cannot give consent. Or there is no way in which you can show animal giving consent. As long as consent is involved, everything is okay. Since animals cannot be seen to be showing consent, that's why bestiality should not be allowed. But sir, ordinance can be used to amend constitution in some cases. No case. No case, full stop. Ordinance can never be used to amend the constitution. Sir, if our constitutional rights are violated by government, then what we can do? You can approach the High Court, then you can approach the Supreme Court. Sir, how 368 procedure of amendment doesn't give power to Parliament initially? Because the title mentioned procedure for amendment. The court said, look at Article 368. The title itself says procedure for amendment. It does not give power to the Parliament to amend the constitution. So what we will do, So can Supreme Court never take up suo motu cases? The courts can take suo motu cases on its own. But in this case, it did not take it up. That's also the discretion of the court. There are 8 minutes left in the class. We can't discuss right to equality because it involves an elaborate discussion of about 1 hour. So we can't start it and then leave it midway. What I will do, I will take questions for the remaining 8 minutes. Those who have no questions may go. We will meet tomorrow 6 o'clock in the morning. Those who have questions, please stay. I will take all your doubts till 9:30. After that, I will also go. Okay? But don't go without rating the class if you have enjoyed today's session. Let me know. Sir, in short, we can say Parliament can amend fundamental rights except violating basic structure. Yes. Example of the Supreme Court SC reservation. Was it injustice, sir? We will discuss this tomorrow when we will discuss Article 16. Then you will not think that this is injustice. You will think that this is part of social justice. New CRPC and IPC, please tell about that. That new bill has not been passed yet. Once that is passed, we will discuss. Sir, please answer how Madam Gandhi amended Article 368. Madam Gandhi did not amend Article 368. Parliament amended Article 368. Madam Gandhi was the Prime Minister. How could she have amended? You can still do that. That's for the court then to decide whether this was done legally or illegally. So does Parliament have the power to reverse the order of the Supreme Court? In some cases, yes. If the underlying condition of the judgment is altered. What is the underlying condition of the judgment? For example, Shabano. She was an old lady, more than 60, 70 years old. She was married to an advocate of the Madhya Pradesh High Court. But the husband fell in love with a younger woman and divorced Shabano. Shabano asked for maintenance. But according to the Islamic laws, maintenance could be provided only for 3 months, not for the entire life. She approached to Madhya Pradesh High Court. My lord, I have a doubt. I have a concern. So what's the concern? If my fellow Hindu sister is divorced, she gets maintenance for her entire life. But as a Muslim woman, I get maintenance only for 3 months. Is this not discrimination on the grounds of religion? Madhya Pradesh High Court said, you are right. Shabano's husband, ex-husband, you provide her maintenance for her entire life. Matter went to the Supreme Court. Supreme Court also said the same thing. Provide maintenance for the entire life, not only for 3 months. Then there was a lot of hue and cry amongst the custodians or so-called custodians of the Muslim faith, the clerics, the Molvis. They started protesting, and some of them approached Rajiv Gandhi as well. Rajiv Gandhi, a suave, good-looking gentleman prime minister, he listened to these individuals and ultimately passed a law in the parliament known as Muslim Women Protection of Rights on Divorce Act, 1985. The very logic given by the court was, since compensation is less, that is why this compensation cannot be satisfactory for this woman for her entire life. That is why you have to pay compensation for the entire life. This was the underlying judgment. Parliament in its law said, we will increase the compensation. The maintenance amount will be increased in such a manner that this amount lasts for the entire life. But this amount can be paid only for 3 months, according to the Muslim law, not for the entire life. So Parliament has the power to nullify the judgment of the Supreme Court only if the underlying condition is changed, is altered, is touched upon. Otherwise, no. this individuals as well, which we will discuss tomorrow. For example, Article 15, Clause 2. No citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth. That we will discuss tomorrow. Supreme Court. And clearly not on the grounds of violating fundamental rights, because BCCI is not a state. Example of Shabano verdict of 1985, we'll discuss the Delhi case when we will talk about union territory. There we will discuss the Delhi case. So section 377 is partially struck down, which means section 377 is read down. People who done this shouldn't be punished. They are punished now, because we have a law passed in 2017 known as Muslim Women Protection of Rights on Marriage Act, according to which if the husband pronounces instant triple talaq, that's what we call teen talaq, instant triple talaq, it's a crime and the husband can be sentenced to 3 years in jail. This question before, you can approach the High Court, not Supreme Court directly. That would be the violation of the Atrocities Act. If you belong to SC community or ST community, you have to file an FIR. You don't have to approach the Supreme Court. If the police refuses to file an FIR, then you can file a petition before the Supreme Court. Regarded for its preamble as part of the Constitution, it's the same case, but so many things were decided by the Supreme Court in that case. That is why you will see this case being cited forever. We'll discuss Articles 14 to 18, which deal with this category, right to equality. See you tomorrow. Till then, have a great time.